Welcome everyone back to episode 2 of From Anti to Ally, the show where I, Barry Regan, professor of communication at Central Arizona College, talk about how to use white privilege and use knowledge of social injustices happening for good to enact positive change in the world. I want to start off by saying a huge thank you to everyone who sent me, messages of support, who shared episode 1 where I talked about what is white privilege, how it functions, and benefits to interrogating white privilege. I really thank everyone for their feedback. Outside of the one YouTube commenter who said, since you're an expert at white privilege, tell me why I haven't gotten every job I applied for. So outside of that, I appreciate the constructive feedback that I've gotten. And I want to start off today by doing something that I hope to do at the beginning of every episode from here on out, is to dedicate this video to people who have lost their lives in the pursuit of justice, equality, and the breakdown of structural racism in our country. So this episode, as you'll see at the end, is dedicated to Botham Jean and to Laquon McDonald. One of the feedback I got from episode 1 was people were saying, hey, this is great info, but it was really long, it was really theoretical, and I'm not really sure what this means in terms of action. And I've been thinking a lot the past few days of how can I maybe shorten the video, focus it on one issue, so that way we can start creating coalitions of action on a broader scale. And there is one court-based issue and a Supreme Court-enabled barrier that I think is enabling officers and law enforcement who use excessive force that allows for them to not have accountability and for them to not have justice held against them. And that is the issue of qualified immunity. And so today what I want to do is to talk about how qualified immunity works and how it's been used to protect law enforcement officers and other law enforcement officials to engage in excessive force and oftentimes ending lives and have nothing happen. And what I hope is, we're recording this on June 2nd, Tuesday, June 2nd, 2020. I'm seeing a lot of people I know, friends and family, to put the blackout page on Instagram and Facebook. And I think that's great to raise awareness. But I hope that you also raise awareness of this issue, because qualified immunity, as you'll see, I think is one of the biggest barriers to creating justice for breaking down structural racism and saving lives. And I hope that you will share information from this video today, so that way we can start enacting true change in our system. So the first question, of course, when you hear a term like qualified immunity and saying that it needs to end, is you, of course, ask first, what the heck is it? So I want to talk a little bit about what qualified immunity is on a basic level before going into how it, I believe, functions in terms of recreating the problems of structural racism in our justice system. So the first thing to note about qualified immunity is that in this case, qualified immunity essentially means acquittal without trial. That is, an appellate court, which is a court level below the Supreme Court, is given an excessive force complaint filed by a civilian against a police officer or law enforcement official. And the appellate court goes through a two-step process to evaluate if the police officer acted in an unlawful way that means they should then face trial. Now, if you're thinking, this seems a little strange. This individual committed excessive force and may have killed someone. They have to go through multiple steps before they even face trial. And if you're say, concerned by that or even horrified by that, I think that's fair. And to be honest too, from police officers I know who go through the training, who act in proper protocols and methods, I think are also a bit concerned about this as well. Because here's the thing, police officers who do things right, who act within proper training protocols, don't have to worry about qualified immunity. It's the folks, as you'll see, who have been caught up in the deaths of Tamir Rice, of Eric Garner, of, as we'll talk about, Laquon McDonald, Botham Jean, George Floyd. Those are the officers that have benefited most from qualified immunity. And as you can see, even just from the beginning, the fact that multiple layers have to be broken through before to even get to a trial for those officers presents a real problem. So let's talk about this test, because as much as it is a two-part test, as you'll see, unfortunately, it doesn't always work that way. So let's start with part one. So part one essentially takes into account the role of the Fourth Amendment in the excessive force complaint. So excessive force complaint by civilian comes forward, appellate court goes to step one and says, did this police officer act in violation of the Fourth Amendment, which is the lawful search and seizure amendment? And so this is an important step that ought to be, as you'll see, not always, but ought to be considered, because this is one of the foundational components of the Constitution and is one of the foundational, most precedent-setting ways to evaluate, did a police officer go too far in their line of duty in enacting violence or potentially even killing someone? So what works is the appellate court can say, no, we don't see the proof that the police used excessive force in violation of the Fourth Amendment. Therefore, qualified immunity is immediately granted, which essentially means you're free to go. Now, let's say that they say, you know what, actually, this is a violation of the Fourth Amendment of the search and seizure law. We then have to move to part two. Here's the hard part, though, and this is where I think things really kind of get scary. The Supreme Court, since 2009, has enabled and allowed appellate courts to skip part one and go straight to part two. Now, you could say, you know what, this is a good thing. That means there's less layers of bureaucracy they have to go through before they face trial. The problem, though, is to skip over one of the foundational Bill of Rights as a manner of which to evaluate, did a civilian's rights get violated by this use of force? To skip over that, I find to be a problem. Right? And it becomes a problem because without the evidence that's presented at this step, it often makes it harder to prosecute, not just in step two, but even if it goes past step two to a court trial, to even get a guilty verdict in a court trial. So skipping over a part one, a problem. So let's say either the court rules, okay, excessive force violated the Fourth Amendment of the civilian. Let's move on to part two. Part two is where you'll notice one word in particular is really important here. So part two is where the appellate court then has to determine whether the police should have known their actions violated the Constitution because precedent established their conduct as lawful or unlawful. There's one word I want to pay close attention to here. That's the word known. And for those of you who are far smarter than me and have training in the law, whether going or went to law school or practice law, you'll note this is hearkening back essentially to proving of intent, right? So now if you are defending a civilian who is bringing an excessive force complaint against an officer, you have the additional burden before even getting to trial that there has to be a level of intent or knowledge beforehand that the police was violating the constitutional right of that citizen. Now, here's why intent and knowledge beforehand is key. If you go back and research court cases I mentioned, specifically Eric Garner, Tamir Rice, even though it was slightly different, Trayvon Martin, a lot of those instances, police officers, when they have to go before the appellate court, have often said, didn't know if they had a gun, thought they were reaching inside their pocket for a gun, didn't know what they were going to do. I felt my life was threatened, therefore I had to act quickly. Now, I think we all know there are times when officers are truly in danger. They really, truly do feel threatened because someone is brandishing a gun and threatening their lives. The problem, though, is that in those instances I mentioned, specifically Tamir Rice and Eric Garner are two key ones here, the court essentially took their word for it, right? Tamir Rice had a little toy gun. He was a little kid. And the court bought the idea that, look, we need to give this officer qualified immunity because, hey, he didn't know whether it was a real gun or whether what was going on. And I'm not here to litigate specific court cases like that, but instead to say there's a huge pattern amongst people who have lost their lives at the hand of police officers. And the police officers don't even reach trial because they make the same argument over and over again. I felt threatened, I had to defend myself. one of the biggest reasons why I think this contributes to the system is that if you believe the officer and you're the appellate court, they don't even have to face trial, right? They don't even have to go to trial and have to prove their case in court. And so one of the biggest reasons why I think qualified immunity is so problematic on a structural level is that it prevents all sorts of barriers for people to even get out enough evidence to make their case. And it builds in language in court precedent that makes it harder to hold officers and law enforcement officials who use excessive force accountable. And if you think, okay, all right, Barry, yeah, maybe this is a problem, but how much is this really impacting things? Well, I have unfortunately not so good statistics to show you on this front. So there's a Reuters article that I'm going to link to in the description of this video. And it shows, just like it does here, how excessive force and how it's been adjudicated by appellate courts, it's actually getting worse for plaintiffs or civilians coming forward with complaints against police officers. From 2005 to 2007, the appellate courts ruled in favor of the plaintiff saying, hey, excessive force was used. And they ruled in favor 55% of the time. But look at 2017 to 2019. From 2005 to those 2 years now, it's down to 43%, which means that nearly 60% of the time when excessive force complaints come forward, appellate courts are ruling either no excessive force is used, excessive force was used, but no precedent clearly establishes it as unlawful, or that no precedent was set whatsoever. What you can see then is the problem is getting worse. More and more officers using excessive force are not only having to, they're allowed to skip over step one to see if they violated Fourth Amendment rights. They are now have a playbook to get out of excessive force complaints by saying, didn't know, thought he had a gun, thought my life was threatened. In a world where so many people now realize the amount of loss of life that comes from especially Black and brown folks experiencing state-sponsored violence, I hope you see now why something that sounds as strange and as weird as qualified immunity is an important factor in why injustice continues to happen. And I understand if many people at this point are thinking, what's the point to all this then? Like, how are we supposed to do anything in the face of all these barriers to justice? Well, I do have a slight sliver of hope to give you, and that is raising awareness, putting public pressure on public officials, creating campaigns of justice for people who not only have lost their lives, but their family members don't even get justice for the people who took their lives. There are signs that public pressure can work. And I want to highlight two examples in particular that went to trial in 2019 that I think show that the more public pressure gets put on this, the more that can be done. So the first one was the horrific shooting of 17-year-old African-American Laquon McDonald in Chicago. For a couple months, his death, there was no footage released. But eventually, Chicago Mayor Rahm Emanuel released the footage of Officer Jason Van Dyke, the man on the right, essentially pretty clearly killing Laquon McDonald in cold blood. Van Dyke was not given qualified immunity, faced trial, and actually convicted of second-degree murder, which, to be honest, was pretty stunning because there had been so few instances of even someone who was unarmed that an officer who killed them and they were unarmed even faced murder trial, but was convicted as well. The second one that also, the court case also happened in 2019, was the case of Botham, African-American man on the right, who was sleeping in his apartment in Dallas, Texas. And off-duty police officer Amber Geiger, the woman on the left, broke in thinking it was her apartment, saw Botham lying there, thought that he had broken into her apartment, shot him and killed him. She was not granted qualified immunity after public outcry and was found guilty of a 10-year prison sentence. Now, I would say 10-year prison sentence was too light, but I think the larger, if you're trying to look on the bright side here, the deaths of Botham Jean and Laquon McDonald and the public pressure that advocates put on the appellate courts and public officials to really prosecute those officers helped bring justice in ways that hadn't really happened before, right? In 2019, the fact that multiple officers who murdered unarmed African-American men were charged and found guilty of murder just doesn't happen. Now, does this mean the problem is solved? Cool, now we're good. Public pressure is going to solve everything? No. But what I ask those of you watching this video and who care about this issue and see now why qualified immunity should end, I hope that you realize putting pressure by ending qualified immunity, by making sure that, say, Derek Chauvin, the man who shot and killed, or not shot and killed, but who kneeled on the neck of George Floyd and killed him, you make sure by putting pressure and ending qualified immunity, of making sure that there is a fair trial that Derek Chauvin has to face. That's how we can start creating steps to change. Okay, so I always end these videos by saying, don't stay silent, please speak up. The more that you can go beyond just saying Blackout Tuesday, and the more you can raise awareness on ending qualified immunity, the more we are taking qualified or more concrete steps to create real justice and real change. So that way we know the lives of Laquon McDonald, Botham Jean, and George Floyd don't go in vain. Thank you.